All right. Hello, everyone. Hope everyone's doing well. Welcome back to Civil Procedure. We're in the middle of talking here about discovery. And a discovery, that people recall, is the process by which we get the facts out. So this is the fourth step on our road to justice, the conventional civil action. And on Thursday, we talked about one of these 5 tools in the toolbox of discovery, right? So many different facts, many different sources of information and facts that are going to be relevant in the civil action. Therefore, the system has many different ways to get at those facts. And documentary discovery is the one we talked about, which is going to get at anything which is written down or recorded in any way, including electronic mechanisms, and make sure those things get on the table. And we saw that documentary discovery is meant to be a voluntary process, which in principle unfolds without any necessity for court involvement. Every party discloses the existence of all relevant documents and then produces those documents which are in their power and control, over which they do not make any claim of privilege. But of course, this is civil litigation, so disputes arise, and we have opportunities for lots of fun procedural motions about documentary discovery. The court, in adjudicating a motion about discovery under Rule 36, is trying to balance all these good things, right? More disclosure means better access to the truth in principle, but more disclosure also means, more expense. It may, in some cases, mean more potential disclosure of privileged documents, and then, relevance. The relevance inquiry can also limit what the plaintiff or what the party seeking disclosure wants. I should also emphasize, before we go on, that these can go both ways, right? So a discovery motion can be brought by a defendant just as well as by the plaintiff. Here it was the plaintiff who happened to do it, but defendants also have a strong interest in plaintiffs disclosing things. And if they feel that their entitlement has not been met, then they also have access to this system.
So that brings us to the end of what we're going to say about discovery of documents. Okay, so a question about this balancing act slide. My point is just here that that on the one hand, the court, in hearing a Rule 30.06 motion, is, the search for truth. Litigation is a search for truth, and that consideration weighs towards more fulsome discovery, more fulsome disclosure and production. But on the other hand, we don't want to make parties disclose and spend time just looking for documents that might not be relevant. We don't want the process to become disproportionate, and we definitely don't want to be compelling disclosure of privileged documents. So when they're trying to balance these things, those are the kind of considerations that you'll see at play when you look at endorsement or a ruling on a contested discovery motion. Okay, so coming back to the toolbox of discovery, right? We've talked about discovery of documents. A couple of other ones we'll look at quite quickly. Inspection of property. So this was in your readings, Rule 32. Okay, so this comes into play where there's some sort of physical object or piece of land which is at issue, right? So clearly in real estate litigation, people are arguing over their backyard boundary or something like that, then you're going to have to, the actual land itself is going to be relevant in the same way a document would be relevant. Or there's a physical object sometimes, which is relevant. So when that comes about, you can seek a court order for inspection. And then the court might order that one party allowed to go on to another party's property. They may also order a third party to do this. Again, hopefully the parties will cooperate to avoid the necessity for bringing a Rule 32 motion. But this is here if the court's involvement is necessary to get the parties to disclose that, right? So just because it's a thing or a place does not change the fundamental policy of the law that we want parties to voluntarily disclose and let everyone else know what they need to get at the truth. All right, we also have this Section 105 of the Courts of Justice Act regarding a physical or mental examination. So this is used more commonly than Rule 32. And in particular, it's used in personal injury litigation, where the extent of a person's injuries and the level of damages to which they're entitled is very much a live issue. So under Section 105, a court would order a person to be evaluated by a medical professional, a health practitioner, chosen by the other side, by one of their adversaries, right? So you might have heard of a defense medical as something which happens in motor vehicle cases, which means that the plaintiff is going to be examined by a doctor who has been hired by the defendant, by the insurance company typically, right? So not a typical doctor-patient visit, right? Most of what doctors do is supposed to be about making the patient better. This defense medical is about gathering evidence on behalf of a party who is adverse in interest to that plaintiff. And it also says that the authority of the party and the authority of the party is, or sorry, the authority of the court is enough to do this, right? So you don't have to consent. So it's kind of a path around the normal requirement that patients consent to treatments. Because if you don't consent to be examined by this health practitioner under Section 105, then your case can be struck out. Okay, so that's 3 of these. The fourth one is a big, important one, right? Examination for discovery. So this, you may have seen, you may have participated in this in one way or another, or you may have seen it on the screen. It's known as a deposition in the United States. Examination for discovery is our term. And an examination for discovery usually follows the documentary discovery phase in civil litigation. And it typically takes the form of an interview, an oral interview about any matters that are relevant to the case. And it occurs out of court. So what happens is the parties will basically take turns examining each other. So if you're being examined for discovery, then you will have to go to a facility like a conference room type facility, and a lawyer, or in some cases a self-represented litigant, who is your adversary in the civil litigation, will ask you a series of questions about matters relevant to the dispute. And at the end of the class, we'll watch a video clip that kind of shows how this works. But first, we should talk about why we do this, right? What is the value of examination for discovery, and where would it fit into your litigation strategy? So the first and most obvious purpose of examination for discovery is to get at documents, get at information which is not contained in documents. So you may remember on Thursday we talked about a telephone call, right? And how a telephone call that leaves no record, which and relevant matters are discussed in that phone call, that cannot be disclosed in documentary discovery because there's no document to disclose. But the substance of that phone call is relevant, and a party who participated in it would be required to answer questions about it, and that's how you would figure out what relevant information was communicated in that call. Okay, so purpose number one of this, getting at information which is not has no physical residue. Second big one is building a case for the disclosure of documents. So does anyone remember going back to last week and the Leduc and Roman case? Remember Leduc and Roman, the Facebook profile case, and this personal injury plaintiff who might have secret water skiing photos in his private Facebook profile? Is anyone able to tell us, perhaps using your microphone, what the relationship between examination for discovery and documentary discovery was in that case? How was the defense going to have to use examination for discovery in order to support their argument for documentary disclosure? That's right. So if you can ask the questions in examination for discovery, and then the answers constitute evidence that something relevant has been withheld, that would be the basis for getting that order to compel disclosure of those documents. Okay, so that's the second big purpose of examination for discovery, to create the basis for an order for further documentary disclosure, or just, hopefully without even requiring a court order. If a certain set of documents are disclosed, and then you have examination for discovery, and in the process of that examination, the answers of the examinee indicate the existence of further relevant documents which are not on the original affidavit of documents, then you can say, will you please disclose and produce those documents? And probably going to say yes, right? Because it becomes obvious that those documents are relevant and therefore disclosable. So sometimes in complicated cases, a lot of documents, there's kind of a back and forth, right, between the affidavit of documents, the examination for discovery, and they kind of support each other as you pursue this strategy of trying to get at all of the relevant facts that might help your case. Okay, there's a third important purpose, strategic purpose of examination for discovery, and that is to impeach the credibility of witnesses. So when a witness is examined for discovery, that commits them to a version of the facts. And then subsequently, if you end up in trial, you can ask them about the same things that you asked them about in examination for discovery, right? And if there's a difference between those two versions, that undermines the credibility of that witness and helps your case in that way, right? So it's called prior inconsistent statements, and those of you who can evidence may have touched on this. That if you're trying to show a jury or show a judge that a certain person is not to be trusted and that they're not credible, a very powerful way to do that is to say, look, when I asked similar questions a month ago in the examination for discovery, they gave different answers. And that makes everything they say less credible. If the person is literally lying, it's much harder to lie if you have to tell exactly the same lie twice about the same facts in response to different questions, especially if the questions are skillfully phrased. And even if they're not lying, even if they're just forgetful or unreliable for some other reason, any discrepancy between version at examination for discovery and version at trial will help you establish that lack of credibility. All right, so let's look at the some of these rules here for examination for discovery, starting with Rule 31. 31.03, you generally only get one kick at the can, right? So you can examine for discovery any other party adverse in interest. So this, of course, is a right which every party has. The defendant, the plaintiff, and any third parties each have the right to discover each adverse party, which is each party opposed an interest to them once, but generally not more than once. 31.02 we'll get to a little bit later. You can examine if a party adverse in interest to you is a corporation or a government entity, you can generally only examine one representative of that party. So that's presumptively going to be the deponent of the affidavit of documents. You recall that in the case of a corporate party, someone in that corporate party, some executive who knows about the matters in issue, is going to be required to swear that these are all of our documents that are relevant and do the schedules to that and so forth. Typically, that's going to be the same person who will appear at the examination for discovery to answer questions on behalf of the corporate party. But that may be negotiated, right? Maybe the party examining might say, well, what are you doing trying to fob off this middle manager on us? We want to examine the CEO of the company, and then that can go back and forth. That can end up in court, right? Who's an appropriate examinee? But if you're the examining party, you want someone who knows as much as possible, right? Because they're going to be able to give you the best information. It can end up before court, but again, it's something that we want the parties to be able to negotiate amicably without the necessity for a motion. So you're just allowed to examine one person, but you are allowed to ask them to obtain relevant information from other people within the organization. So that's what an undertaking is that we'll talk about in a second. 31.06, person examined for discovery shall answer to the best of his or her knowledge, information, and belief any proper question relevant to any matter in issue in the action. So the relevance test, right? We have here a relevance test, which is the same Peruvian guano test that we have on documentary discovery. But it says any proper question relevant. So what else other than irrelevance would make a question improper and therefore not subject, a question that should not be answered by that examinee? So obviously irrelevant questions, not proper. Okay, so some great ideas here. So the big one, the one that probably comes up most often, in addition to the question of relevance, would be privilege, which several people said, right? And privilege will be on Thursday, but you do not have to respond to any question that would require privilege information. Too broad, potentially, if it's the questioner can be required to narrow it if it's so broad as to be incomprehensible, or the question so broad that it would take an hour to respond to it. Then the lawyer for the examinee might require the examiner to sort of narrow it a little bit. So leading questions are not generally a problem. This is sort of an adversarial process, and you're allowed to ask questions which are designed to kind of get the other side to admit something that they shouldn't, or that they would rather not. And harassment is a thin line, right? I mean, as we'll see, it's entirely proper to ask questions that are quite aggressive in a way, right? Not ad hominem or irrelevant questions, but if it's getting at relevant non-privileged information, you've got fairly broad scope to do that. Okay, so this will become a bit more clear hopefully when we see a couple of examples of this. So 31.06 is where we were, right? So this is something that that's similar. This is a point of similarity between documentary disclosure and examination for discovery, is that you have to answer questions that are relevant, right? You have to tell the truth if you're being examined, whether it's bad for your case or not. However, there are also some pretty big differences between this discovery for documents and an examination for discovery. Examination for discovery is much more adversarial, right? Discovery of documents, you're required to voluntarily disclose and produce. In an examination for discovery, you are not required to volunteer anything unless you are asked the proper question. Right? So if there's something you know that is relevant to the matter and issue, and it would definitely, perhaps even be dispositive, totally change what the legal outcome would be, but you are not asked a question about that, then you do not have to volunteer it. So what that means is that conducting an examination for discovery as a lawyer requires much more skill than simply receiving documents from the other side. Because if you're examining, you have to have the right questions, because if you don't, then you won't get the right answers and you won't get that information that the examinee has. So 31.06 also tells us about some reasons, some non-reasons, some things which are not acceptable for refusing to answer a question, right? So 31.06, no question may be objected to on the ground that it's evidence, right? Because that's the point, is to get at the evidence. You can't refuse on the grounds that the question constitutes cross-examination. So this is a lot like cross-examination, except unless the question is directed solely to the credibility of the witness. Okay, so this is kind of a subtle distinction here. A question directed solely to the credibility of the witness might be like, you're lying, aren't you? Or how can you think that you can tell us such a blatant falsehood when you're under oath? Those would be questions directed solely to the credibility of the witness, to which the witness and their counsel can legitimately object. However, you can ask questions which are designed to kind of confront the examinee with contradictions and are designed to show the audience, because you're in this conference room, you're not in court, but the entire transcript of what happens will be visible to the fact finder at trial. So you're putting on a show for them, and the questions you ask can properly be designed to show that audience that this witness is not credible. So you can ask, didn't you mislead us earlier about Y, right? Or, weren't you found in an earlier proceeding to have misrepresented the state of affairs regarding X? So that's all fair game. There's a rule here also about failure to answer on discovery. So a party or a person examined for discovery on behalf or in place of a party fails to answer a question if you literally refuse to answer. So this is part of the role of counsel for an examined party, is to object to questions which are irrelevant, touch on privileged material, or purely repetitive questions. Like if the question has been asked and it's already, then they can't answer it again. So that's another basis on which you can object. But that's considered a refusal to answer. So that's a refusal. It's also considered a refusal to answer if you indicate the question will be considered or taken under advisement. So taking under advisement is where you have not yet decided whether you're going to answer that question. You have not yet decided whether it's appropriate to claim privilege over that or not, right? Because of course this is fast. You don't know what the questions asked your client are going to be, so it's acceptable if you don't know to take it under advisement. And then if you subsequently decided that it's relevant and non-privileged information, then you will provide it in some documentary form to the examining party. So if you say that, but 60 days go by and you still haven't, then you are deemed to have failed and refused to answer that question. Or if a party or other person undertakes to answer the question, but no answer is within 60 days after the response. So an undertaking, what's an undertaking? We talked about an undertaking, right? What does that word mean?
Hi, so basically an undertaking is like a formal pledge, or you're basically agreeing to provide the document or the information discussed.
Yes, that's right. That's right. And especially a lawyer's promise, right? So if a lawyer undertakes to provide something, and that's something that a lawyer would often do in an examination for discovery, it becomes a matter of legal ethics and of your professional obligation to follow through on that undertaking to the best of your ability. Okay, so that's great. So if you make that undertaking and then you don't come through with the stuff in 60 days, then you're deemed to have failed to answer. And then if any of these things happen, so what are the consequences of a failure to answer? The effect of it, first of all, you may not introduce at trial the information that was not provided, right? So this is another application of our policy against surprises, right? No surprises in the civil procedure. So if someone has got some devastatingly valuable piece of information that they think can win the case, and they want to hold on to it for trial, so the other party doesn't have a chance to prepare a response to it, that's the system does not like at all. So that means that if you are asked a question in examination for discovery to which your smoking gun, devastating information would properly respond to, and you don't provide that information or you refuse to answer the question, then you cannot use it at trial, except with leave of the trial judge, which would be very seldom granted. Okay. So that's one thing, and of course, if you are found, if the party, if you refuse to answer, and the party who is asking the question, the examining party, feels that it's a proper question pertaining to relevant material that's not privileged, then you end up going to court and having a refusals motion. It's called a refusals motion when it's a procedural dispute about whether or not a certain question would be relevant and appropriate to be answered or not. Okay. So I'll just say one other thing about undertakings before we leave that. This will often happen if there's information which is unquestionably relevant, unquestionably non-privileged, but you just have to dig to get at it, right? All right, so last little rule on here, the effect of a lawyer answering. So the idea of examination for discovery is not that lawyers ask questions to lawyers, but rather that it is a party or a representative of a party who will be giving the answers, because this is all about evidence. It's all about getting at the facts. And the presumption is that people who are really involved in the matters in real life, who actually were witness to the subject matter of the dispute, are going to be the ones who have the best information. So it's only an exceptional circumstance in which a lawyer for the examinee be allowed to answer the question. And so basically you have to have permission, right? So basically the examining party has to have no objection. They have to allow the lawyer to do it. And if that happens, then the lawyer can answer, and it will be deemed to be the answer of the person being examined. But if you're examining, you don't generally want to allow that unless there's a good reason, right? Because if you're trying to get at the facts and get the facts that are going to help your case, they're more likely to come straight from the horse's mouth, so to speak, as opposed to coming from a lawyer who has been in 15 or 1,500 examinations for discovery before, and knows how to answer in a way which perhaps minimizes the disclosure of information which is helpful to you. So this examination for discovery, again, like all discovery, is supposed to happen without any court involvement, but we have no one is monitoring this as a matter of course, and judges would rather not hear anything about it. It's only when a dispute arises that the parties end up before the court. So I talked about the refusals motion, right, where the parties are in a disagreement about whether a certain question is proper or not. So that's something you can have a motion over. And then this case, Lammie versus Belair, is another example of a motion arising from disputes pertaining to examination for discovery. Okay, so the examinee's lawyer, right, the lawyer representing the person being examined, or representing the corporation which employs the person being examined, is supposed to be passive, right? They're supposed to be passive but vigilant. But they do need to be in the room because they have certain functions. Why do you need to be in the room? Why do you need a lawyer in the room? Why would an examined party typically want to have their counsel there? Okay, to be able to object to and to refuse questions. Yeah, that's right. So to object on the basis of any of those things that we talked about. It's also to give them subtle signals. Okay, so subtle signals of what? When questioning follows the rules. Okay, all true. Yeah, don't answer. Yeah, that would be perhaps a not so subtle signal. Don't answer that. It's because it's not relevant, privilege, etc. Okay, and also of course to give those undertakings and take questions under advisement. Okay, so this case, Lammie versus Belair, shows us what not to do when you are representing a party in an examination for discovery. So Elaine Lammie was in a car crash. She claimed that she was her injury prevented her from working. She was party to an auto insurance contract with Belair Insurance. And she would, under the insurance policy, receive income replacement benefits if she were truly unable to work in the long run. So Belair Insurance paid these benefits for 6 months, and then they said, that's enough, you're capable of going back to work now. So Lammie retains a lawyer by the name of Lou Farrow, and she sues the insurance company. So this is all so far just absolute garden variety personal injury case, right? It's about damages. In some cases, it may also be about liability. But what makes this highly unusual is that Lammie has not only sued Belair Insurance, she's also sued the adjusters. Okay, so Lammie sues, and this is kind of Lou Farrow's sort of aggressive strategy. We're not just going to sue the insurer, we're going to sue these adjusters who are in their personal capacities. Very unusual, right? Because these are just kind of employees who do this work for the insurance company, and now we're saying we want personal damages from your personal bank account, Mr. and Mrs. Adjuster. Okay, so these claims go nowhere, right? You read the bottom of paragraph 1, the plaintiff had to discontinue these claims as against the employees of Belair. So they had to drop the claims against the adjusters, which were quite irregular. And then at the completion of the plaintiff's case, Belair successfully moved for non-suit, which is to say you don't need to worry about non-suit. It's kind of an old idea, but it's a function of the court's inherent jurisdiction, where a defendant can basically get the court to say this case is garbage and we're throwing it out. And then, so a lot of Lammie's case was knocked out completely. The trial continued to verdict on the sole issue of Lammie's ongoing entitlement to income replacement benefits. The jury found that Lammie was not so entitled, and accordingly, the action was dismissed. Non-suit is kind of like summary judgment, but less formal. Okay, so she lost. Now, so the car crash victim and her lawyer Farrow have lost, and this is the costs hearing, right? And we'll get into costs next month. But all you need to know for current purposes is that the costs phase of litigation can be used to compensate and sort of punish parties for bad things they did in the course of the litigation itself, right? As opposed to before the litigation began. So what was wrong? And Farrow, the lawyer, is in trouble here. Who can give us an example of something we did during the examinations for discovery that the court is displeased by? Right. So he stepped over the line both when he was when his client Lammie was being examined and when he was doing the examination himself. Right. So paragraph 16 to 27 are all about the bad stuff he did when his client was being examined. He objected excessively. He was rude to the counsel during the examination. He threatened the examining counsel. And then there's this long quote of how invasive he was. So basically, if you are examining, if you're the lawyer examining a party, it's your show, right? You come in, my wife did this just a couple weeks ago. She spent a long time preparing a huge list of possible questions for an examinee, right? That's where, it's one of the moments where you'll stay up late, probably the night before, maybe even not sleep that well if you are the examining lawyer, because you got to have the right list of questions to follow that witness wherever their answers may lead. Because if you don't ask the right questions, then you won't get the right information. If you are the lawyer representing the examined party, you should sleep pretty well the night before, and you shouldn't have to stay up late because your role is generally passive. You have to be alert, as we heard, to questions that need to be refused and so forth, but it's not your show. Farrow, when his client was being examined, basically tried to turn it into his show. He was telling his client what to say, what responses to give, which is not allowed. Except in very defined circumstances where the question is inappropriate or privileged. Paragraph 24, he would interrupt questioning on several occasions to give his views, which at times approached a dramatic monologue, right? So he's got this theory, right? This guy is, to his credit, he is motivated by a sense of what he considers social injustice. He thinks the deck is rigged against personal injury victims, and he thinks, insurance companies kind of conspire with these adjusters to undermine the access to benefits that plaintiffs are supposed to have. But this was not the time and place for him to advance that theory, right? You have some latitude in pleadings to kind of take a simple case and turn it into kind of a bigger thing, and you have some scope at trial in your opening address and your closing address to do that. You have no scope whatsoever to do that when you're representing an examined party. Okay, so we turn now to what he did when he was examining, right? So Laura Leggett is one of these adjusters for the defendant. And here, in the judge's opinion, he refused to accept even this passive but vigilant role that the opposing counsel was going to take, right? So Laura Leggett's there, she's represented, she's the adjuster, and he basically doesn't let her lawyer do anything. Like he doesn't let them even object to irrelevant questions. He continues with his dramatic monologues, and he doesn't. He basically doesn't allow her counsel to do their role and protects the client from irrelevant questions. Okay. So unprofessional comments are made. Assessors were snuck in their red shirts, so it's not the time and place for developing your theory of the case or for engaging in narrative advocacy. The point of it is to get at the facts, and it's a fairly constrained set of things you can do as a lawyer in examination for discovery in order to do that. Okay, so that's how not to do it. What I want to show you now is how you are supposed to do examination for discovery. So a great, successful examination for discovery. And it's fictional, but it's no less impressive for that reason, in my view. Okay, so the point of examination for discovery, just before we get to the kind of the clip, examination for discovery is an adversarial process, right? For the examiner is trying to undermine the other side and bring facts that would otherwise be suppressed to light. For the examinee, it's also an adversarial process. They have to answer all relevant, appropriate questions, but the examinee within that constraint has the chance to show how convincing their story is, right? And to show the other side how convincing it would be to a judge or jury. And that's what this illustrates. So, so I don't know if you have seen this show. It's my favorite lawyer show. Unfortunately, it's been removed from Netflix, but it's still available. It's got Rose Byrne as Ellen Parsons, Glenn Close as Patty Hughes. It's kind of like this epic 6-season battle between these two. And this part you're about to see comes from season 5. And it's all about this woman, right? Naomi Walling, who died. She apparently committed suicide. And immediately before she died, some private and embarrassing information about her was leaked on the internet by this guy, Channing McLaren. Right, so Channing McLaren is kind of like a Julian Assange, Edward Snowden type dude. He basically publicizes these anonymous leaks about what he considers government and corporate malfeasance. Okay, then he's alleged to have disclosed this stuff about her, which may have led her to take her own life. So in the case, Rachel Walling is the plaintiff. So she's the daughter of Naomi Walling, and she has brought this wrongful death suit against Channing McLaren. So Rachel says that Channing leaked this information, and she says he also assaulted her mother. So Ellen Parsons on your left represents Channing McLaren. And Patty Hughes on the right represents the plaintiff, Rachel Walling. So the clip you're about to see is from the examination of Rachel, right? So the plaintiff is being examined for discovery. And Ellen on the left she used to be Patty's protege, and now she started her own firm, and the firm is kind of struggling. Okay, so let's see if this works. Can people hear the sound? Let me know if you can't hear the sound.
Ellen. Patty. Ms. Walling, before we go on the record, I want to tell you how truly sorry I am for your loss. Thank you. Are you okay to get started?
The floor is all yours.
Ms. Walling, to the best of your knowledge, what were the circumstances surrounding your mother's decision to contact Mr. McLaren's organization?
My mom contacted Channing McLaren shortly after she became aware that there was criminal activity at her job.
You're referring to the alleged insider trading at Princeville Investments?
Yes. My mom discovered Fund 23 was making illegal trades. She was very upset and she wanted to expose what she knew.
Did she tell you why she didn't go through official channels? Why she didn't go to the SEC?
She said she wanted to remain anonymous. She was afraid her career would be ruined if she went public. That's why she contacted Mr. McLaren.
Did she tell you how she contacted him?
Yes. My mom was in Rome for a business trip. She knew Mr. McLaren was living in Europe, so she spoke with him.
In person?
Yes.
And were you at this meeting in Rome?
No.
Then how do you know Mr. McLaren and your mother met in person?
She told me. And she told me they slept together.
Did your mother tell you she sought out Mr. McLaren on her own volition?
What do you mean?
Did anyone force your mom to meet with Mr. McLaren?
No. Like I said, Princefield was breaking the law and my mom wanted to stop it.
So your mother told you she voluntarily sought out Mr. McLaren in Rome in order to ask for his help?
Yes.
Did Mr. McLaren agree to help her?
Yes. He told her to go back to New York and get records of the crime. Then they would meet again.
And did that happen?
Yes. She collected for several months, and then they met again in New York.
Where in New York?
At a hotel.
It's good to see you again.
True.
So Mr. McLaren showed up yet again at your mother's request.
I'm not sure who asked to speak to who.
Did your mother tell you what happened the second time they met?
Yes. Mr. McLaren attacked her.
Sorry about this.
Okay, so we'll just move forward a bit. So this kind of shows her account as she recalls it, including the assault in which a cigar case, she says McLaren threw a cigar case at her mother.
That's quite a dramatic account, Ms. Walling.
Objection. Question would be helpful.
Ms. Walling, did you witness the alleged assault you just described?
No.
And have you ever had occasion to discover your mother lied to you?
No. Never.
Impressive. I don't think most people could say that about their mothers.
Objection. What's the question?
Isn't it possible that your mother may have lied to you about what happened with Mr. McLaren?
Why would she lie? The whole reason she went to Mr. McLaren was to tell the truth about what she knew.
Isn't it possible that your mother may have lied to you?
I knew her, and I could see she was telling me the truth.
When was the last time you spoke to your mother?
I was out with friends. She called to tell me she loved me. And that she was doing better. I told her I loved her. And then I went home later and found her dead.
I'm sorry, Rachel. Aside from that, do you understand that everything you said here today is secondhand knowledge? There isn't one detail you can provide about these events that you yourself witnessed. Everything you can contribute to this case, absolutely all your testimony is simply hearsay.
Objection. Can you please refrain from bullying my client?
Frankly, I'm surprised counsel didn't caution you. Despite your laundry list of accusations, there's nothing you can prove. You can't be certain your mother ever even met Mr. McLaren because you never witnessed them together. Isn't that correct? Answer the question. Do you have one shred of evidence that you can provide to support any of the claims you've made here today?
Yes. I have something.
Well, let me guess, your mother gave it to you.
Yes, she did. But it belongs to Mr. McLaren. He threw it at her. Or so my mom said.
Any further questions?
None of that happened. The girl fabricated the whole story.
Okay, so that's the cigar case, right? It's got Channing McLaren's name on it. So that's physical evidence, right? What if they wanted to examine that? Can anyone type in the rule that would be used if it was necessary to examine that cigar case, perhaps to determine whether it had his DNA fingerprints on it or something, right? Anyone type in the rule that would be used if there were a relevant fact about that. Rule 32, bingo. Okay, so what's happening here? We've got this makes her account sounds like hearsay, right? Because the whole case is based on things that her mother told her. But now she's struck a major blow, right? Because all of a sudden the case is now more than just hearsay. She's got this physical evidence, and that seems to make her case more than just hearsay. So it could be a criminal matter, but as you may know from the O.J. Simpson trial, just criminal wrongs can also give rise to civil disputes. And the one thing you can get from a civil dispute you won't get from criminal law is money, typically. Okay, so you see in this back and forth that the kind of strategic goals that are being pursued in examination for discovery. Each side is trying to convince the other that it's going to lose. Rose Byrne, on for Channing McLaren, is trying to show to them that their case is just hearsay and it won't stand up in court. And the plaintiff is trying to show that this case is substantive and has evidence that will convince a jury. Okay, so we now go on to 2 of the deposition.
Oh.
You all right?
What?
Are you all right? You seem...
I'm fine. This deposition today, if it doesn't go better than last week,
You'll have a lot of work to do.
well, I won't have any work to do.
Miss Parsons, Miss Franklin, you're ready for your conference room. This way. Here we go. As I'm sure you're aware, several of the emails in the leak were written to you. It's clear your mother confided in you, trusted you, didn't she? I told you. We talked a lot. We were very open with each other. I was also looking at the phone records from the day your mother died. Am I correct? She called you several times? Yes. I'd like to ask you about a few. There was a call at 5:07 p.m. Do you recall that? A little after 5, I was coming home from choir practice. I called about dinner. She was upset and hadn't really been eating, so I asked if I could bring something home for her. Okay? And then about a half hour later at 5:49 p.m., she called you. Do you remember why? She wanted me to buy some newspapers on my way home. I told her she should stop reading them. They would only upset her more. So what did you do? She wanted me to buy them anyway, so I did. I see. And then she called you again about 40 minutes later. Do you remember what that call was about? The subway had taken longer than usual. She was wondering where I was.
Got it. Let's see. There's another call I want to ask you about. It was later that night at 11:01 p.m. Am I correct that was the last time you ever talked to your mother?
Yes.
Do you recall what you were doing?
As I said before, I was out. A friend's parents had just gotten divorced. So a few of us were trying to cheer her up. My mom called to check on me.
Are we done here?
I still have 20 minutes.
My client is exhausted. She needs a break.
We only agreed on one break, but I can see that Rachel is tired, so sure. Let's take 5.
Oh, that's a long day. How are you holding up?
I'm fine.
No, you're not. You're fishing in there. You should be going for the jugular, not going through phone records. Well, don't beat yourself up, Ellen. Sometimes the facts just aren't on your side.
There aren't any facts in this case. You said so yourself. It's just you against me.
Well, you've got 20 minutes. Good luck.
Thanks for hanging in there, Rachel. We're almost done. Miss Franklin, can you tell me when 20 minutes is up? I don't want to keep Rachel any longer than I have to.
Of course.
I'd like to go back to that last phone call. The night your mother died, you went out? Yes. You said your mother seemed upset that you left her alone. Why? I told you. My best friend was having a tough time. And my mom had my cell number, so if she needed anything, she could call me. And she did call you. She did check on you, you said? Yes. And that was the last time you ever spoke to her, right?
Objection. Asked and answered.
What did she say when she called? That she loved me? And I told her I loved her. You got to tell her you loved her. I'm sure that must be a comfort. Yeah. Can you walk me through that final conversation? What do you mean? Well, you seem to have an excellent memory for conversations with your mother. I imagine the very last time you ever spoke to her must be pretty clear in your mind. Am I right? Yes, I remember it. How did the conversation start? She called. I answered and asked how she was feeling. She said she was doing better. What did you say? I said, good. Then she asked when I would be home, and I said that I wouldn't be too late. And then she said not to worry. She was doing better. So she said she was doing better twice. Yes. Then what? She said not to worry about her that I should talk to my friend and try to cheer her up. And then what? I said, "Are you sure?" And she said, "Yes." And then I told her that I loved her. Is that when she told you that she loved you? Yes. I said that I would see her soon. She said goodnight. And then I said goodnight back. And then she hung up. And that was it? She didn't say anything else? No, that was all. Okay, Rachel, I'm going to read back the phone call to you. Stop me if I'm getting anything wrong, okay? Hey, Mom, how are you feeling? I'm doing better. Good. When will you be home? Not too late. Well, don't worry about me, Rachel. I'm doing better. Talk to your friend. Try to cheer her up. Are you sure, Mom? Yes, I'm sure. I love you. I love you too, Rachel. I'll see you soon. Good night. Good night. Does that sound about right? Yes. Miss Franklin, could you hand me the phone records, please? Rachel, do you see the column with the dates? And the highlighted call at the bottom? Yeah, that's the call you just described. Next to it, you can see how long the call lasted for according to the phone company. What does that say? 2 seconds. Now, while I was recounting your version of the call, Miss Franklin was timing it. And according to you, the conversation would have lasted at least 25 seconds. There's no way that you could have said all of that to each other, could you?
Objection. The plaintiff does not accept your timing as fact.
Well, you can argue that in court. My question to Rachel is what really happened at 11:01 p.m.? That 2-second call went to voicemail, got disconnected, or you ignored it. What you just recounted is the phone call that you wished you'd had.
Objection. Speculation.
No. Miss Parsons, you're right. We didn't even speak. I just missed the call. Mom? Mom? I answered, but she had already hung up. It was just my mom. I'll call her later. Should we get food? You didn't call her back, so you feel guilty. So you made up that whole conversation, didn't you?
We're done here.
My 20 minutes aren't up, and she is required to answer. Yes, I made it up.
Then how do we know you haven't been lying about everything you've said throughout this entire deposition? You don't have to answer that. Now we're done.
Okay, so I still get shivers when I watch that. I love that. It's her best possible day, right? As an examining lawyer. So hopefully people got what was going on there, right? So Rachel Walling's case is based largely on her recollections, because the mother is dead. That's what it's about. So it's based on what her mother told her, and so her credibility, her personal credibility as a plaintiff, is incredibly important. And that whole phone call, right? Nothing that she said that happened in that phone call was like, relevant to the issue of what Channy McLaren actually did. But the fact that she lied, that she made up that phone call, destroys her credibility as a witness. And what the examining lawyer was able to do is kind of entrap her, right, by luring her into telling a story which is demonstrably false because it's contradicted by the call record, right, which proves that the call itself would only have been 2 seconds. So it also illustrates the interplay between documentary disclosure and examination for discovery, just like in Leduc and Roman, right? So you've got the phone records which have been disclosed, and you've got the examination for discovery, and you're constantly looking for opportunities to impeach the witness based on contradictions between those two things. And yes, so everything that happened there will be on transcript and will be can be used at trial to impeach the credibility of this witness. Prior inconsistent statements. That's right. Okay, so a couple of good questions here about why they had day 2. So it's true you only get one chance to examine a witness, but if you have more relevant questions that can be asked and answered in one day, that examination can go into a second day. Yeah, so the transcript is all the transcript of the phone call. That's right, would be a document for discovery purposes. Can you take a full day in that? 8 full hours would be really hard. I mean, I remember doing one of these as an articling student, and after 4 or 5 hours, you're just exhausted. It's like it's the craziest combination of like excruciatingly boring along with incredibly demanding, because you're always have to be listening to what's happening, and often none of it's relevant. It's all meaningless trivialities. But then there's that one statement, right, that you have to pick up on and you have to follow up on, because it's your only chance to get at the significance of that and get it on the table. Yeah, but it's all from the system's point of view supposed to be part of the process moving forward, right? An apparently reliable witness is now less so, and we now have facts and that we never would have had access to if we just had parties disclosing documents to each other. This is a chance to get at the truth. Okay, so unless there's any more questions about that, I'm just going to talk very quickly about the last item in our toolbox. Can you bury the other slide in non-relevant documents? No, you can't. You're not under Rule 30 to disclose or produce anything that's not relevant. And that's the sort of behavior that, if a court apprehends it, would be very relevant to a costs award. And the other side, if they're sophisticated, would pick up on that pretty quickly. Okay, so the last of these 5 tools I want to talk about is examination for discovery by written questions. Rule 35 in your readings. So this is an alternative to examination for discovery, right? So 30, where is it? Somewhere here it says, oh, right, sorry, it's Rule 33.1 says that an examination for discovery may take the form of an oral examination, or at the option of the examining party, an examination by written questions and answers, but not both, right? So basically you can choose to instead of doing what we just saw, send a list of written questions. And then they have to provide written answers to them. So, after what you just saw, hopefully it's obvious why most parties will choose oral in most cases, because it gives you that chance to uncover things that they're trying to suppress and catch them in lies and undermine their credibility. But why might you, in an appropriate case, choose to elect to proceed by written questions instead of oral? Okay, yeah. So expense is certainly part of it. You don't have to show up there. Could take less time. Okay, so I should say this is at the option of the examining party, right? So the examining party gets to decide whether they're going to ask the questions orally or in writing, not the examinee. So more time to think of an answer would be probably a disadvantage, right? If you want, it's one of the things about oral is you get a spontaneous on the spot. You don't get an answer which has sort of been cogitated or worked on or perhaps massaged to minimize its probative value. But yeah, so the price is an important thing. If you think yeah, allows more detailed thoughts. If you think that it's not really a case about credibility, and you think that they're going to be honest, and if it's a case where, it's more important to give them time to answer in a fulsome way than it is to have the opportunity to catch them in perhaps a misrepresentation, then it might be advantageous to go with this option. But it's one or the other. And then there's forms that you use for that as well. Okay, so that brings us to 650. Any questions about anything we've heard today? These are all tools in a toolbox, right? And you can see that they come into play in different cases. But the point of all of this is to get at the truth. Can you do some witnesses orally examine? So it would be the choice you can make, choose differently for each party. So recall that you only get to examine examine each party once, right? A party to examine so any other party adverse in interest. So if there are multiple people within a certain party who have relevant information, that doesn't mean you can examine all of them, because it doesn't say you can examine every witness with relevant information once. It says you can examine for discovery any other party once, and it's a matter of negotiation as to who that's going to be. No, I mean there's no limit. I mean the limit is the limit of relevance and of relevant non-privileged questions. So it's kind of like trial. You have the right to ask all of your relevant proper questions. The person you're examining is tired of 3. Is that it? No, you would not need to bring a motion for further discovery. So it's considered one discovery, and the timing of that discovery is meant to be arranged between the parties reasonably with regard to the energy level of the witnesses and the availability of the lawyers and so on. And it can certainly stretch over multiple days. Okay, so I think we'll wrap it up there. I'll stick around for any other questions or concerns people might have. But thanks for a great day. And then on Thursday we'll come back with privilege.